Right now, as you're watching this video, federal investigators are sitting inside USCIS field offices across this country, all 80 of them, reviewing naturalization files, not new applications, old ones, already approved ones, citizenship cases that people thought were closed, finished, done. And here is the part that has immigration attorneys on edge. The government has set a monthly quota, 100 to 200 denaturalization referrals per month in 2026 alone. If you are currently in the naturalization process, if your N-400 is pending, if you were recently approved, or if you have a family member whose case touched the Minneapolis-St. Paul area, you need to watch this entire video. Because what I'm going to break down today is not speculation. It is not sensationalism. It is based entirely on official USCIS releases, DHS enforcement reports, and documented legal analysis. Stay with me. This matters. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. Everything on this channel is grounded in official policy, government records, legal filings, and verified reporting. We do not deal in rumors. We do not traffic in fear. What we do is give you the information you need to understand where the immigration system is heading and what it means for your specific situation. And I want to be transparent with you up front. I am not your attorney, and this content is for educational and informational purposes only. Please always consult with a licensed immigration attorney about your specific case. What I do here is break down the policy, the data, and the implications so that when you walk into that consultation, you are informed and prepared. Now, let's get into what is actually happening. To understand where we are today, you need to understand how this all started. Operation Twin Shield was launched in September 2025. Specifically, between September 19th and September 28th, USCIS, in coordination with ICE, the FBI, and other federal partners, conducted what they described as a targeted surge of fraud detection and deterrence activities across the Minneapolis-St. Paul metropolitan area. Now, why Minneapolis? This is an important question. The Twin Cities region has one of the largest Somali and East African immigrant communities in the United States. For years, federal investigators had flagged elevated fraud risk indicators in certain immigration benefit applications coming out of that region. The operation was officially tied to Executive Order 14161, an order focused on national security and public safety threats, and it was authorized under the Immigration and Nationality Act's broad fraud detection mandate. Here is what the operation actually involved. USCIS officers focused on more than 1,000 cases that carried fraud or ineligibility indicators. They conducted over 900 site visits and in-person interviews. They showed up at homes. They showed up at workplaces. And at the end of those 10 days, they found evidence of fraud, non-compliance, or public safety concerns in 275 of the cases that were actually interviewed. That is 44% of the cases that were physically interviewed. Think about that number for a moment. Nearly half. Among the findings, fabricated death certificates used to fraudulently terminate marriages. A man who admitted to purchasing a fake death certificate from Kenya for $100 to falsely claim his marriage had ended, when in fact, that spouse was alive and living in Minneapolis, the mother of 5 of his children. An applicant who was the son of a known or suspected terrorist who had also overstayed his visa and had previously engaged in marriage fraud. A petitioner who admitted to officers, just hours after swearing under oath that her marriage was legitimate, that the marriage was fraudulent. These are not abstract policy violations. These are specific cases, and they are the reason this operation is being expanded nationally. Now here is where this becomes critical, and I need you to pay close attention to this section because this is the part of the story that most people are missing. The DHS official report released on March 5, 2026 confirms that Operation Twin Shield has never stopped. The arrests have continued, the investigations have continued, and most importantly, the scope has expanded dramatically. In February of 2026, just weeks ago, a 45-year-old man named Morris Brown was arrested in Minneapolis. He was a correctional officer for the state of Minnesota, an AWOL National Guard member, and, according to federal investigators, an undocumented immigrant from Liberia who had been falsely claiming United States citizenship for years. He had been working inside Minnesota's correctional system with access to inmates, to records, to law enforcement infrastructure, while having no legal immigration status whatsoever. USCIS discovered him because they were still reviewing Twin Shield cases. His 2024 naturalization application, which he had filed based on prior military service, triggered the review. Investigators found evidence of marriage fraud, false claims to citizenship on multiple prior documents, and a prior green card denial. ICE was called. He was arrested January 15, 2026, and he now faces removal proceedings and potential criminal prosecution. But here is the larger implication of that case. It proves that the post-Twin Shield review process is ongoing. Cases are still being opened, people are still being referred, and now that review is no longer limited to Minneapolis. This brings me to the part of this story that has gotten the least coverage and deserves the most attention. In December of 2025, internal guidance was issued to USCIS field offices across the country. That guidance directed those offices to supply the Department of Justice's Office of Immigration Litigation with 100 to 200 denaturalization case referrals per month throughout fiscal year 2026. Now let me give you a frame of reference for how significant that number is. Between 1990 and 2017, that is 27 years, the Justice Department filed roughly 305 denaturalization cases in total. That is an average of about 11 per year. During President Trump's first term, that number rose to roughly 42 per year. Under the current guidance, that monthly quota alone would exceed the total annual number from recent history. USCIS has been sending specialized experts to its field offices. Staff members are being reassigned specifically to review past naturalization approvals. The agency is looking backwards at cases that were already closed and asking the question, should this citizenship have been granted? Now, I want to be precise with you here. The legal bar for denaturalization remains high. Under the Immigration and Nationality Act, specifically INA Section 340, citizenship can only be revoked through a federal court proceeding. The government bears the burden of proof. They must demonstrate that citizenship was obtained through willful concealment, misrepresentation, or that the person was fundamentally ineligible at the time of approval. This is not a process where someone gets a letter and loses their citizenship overnight. There are legal proceedings, there are courts involved, there are due process protections. However, and this is what immigration attorneys are warning about, the quota system introduces a new pressure. When you instruct field offices to meet a number, the risk is that marginal cases that might not otherwise have been referred, get pushed through to meet that target. This is what many naturalized citizens are misunderstanding right now. And I want to be very clear on this point. The vast majority of the approximately 26 million naturalized U.S. citizens in this country have nothing to fear from this process, provided their naturalization was obtained honestly, their application was truthful, and their documentation was legitimate. Denaturalization law, as it currently stands, focuses on specific categories. First, individuals who obtained citizenship through willful fraud or material misrepresentation on their naturalization application. This means lying about your prior criminal history, concealing a prior marriage, providing fraudulent supporting documents, or falsely claiming eligibility you did not actually have. Second, individuals who obtained citizenship through illegal procurement, meaning the process itself was corrupted, perhaps involving a fraudulent petitioner, a compromised officer, or fabricated evidence in the record. Third, individuals who, within 5 years of naturalization, became affiliated with certain prescribed organizations under the INA. What this does not include, under current law, is penalizing people for crimes committed after naturalization, penalizing people for minor paperwork errors that were not material to the naturalization decision, or targeting people purely based on their national origin or community. Several former USCIS officials have publicly warned that the quota structure could sweep in borderline cases, situations where someone made a minor mistake years ago that wouldn't historically have risen to the level of a denaturalization referral. And there is one more dimension here that almost no one is talking about: the impact on children. Under the relation-backed doctrine in immigration law, if a parent's naturalization is revoked because of concealment or misrepresentation, any children who derived citizenship from that parent can also lose their citizenship. This applies regardless of where those children are living. This is codified in the INA, and it is one of the most profound downstream consequences of a denaturalization proceeding that most people simply are not aware of. Let me bring this closer to home with a realistic scenario. I want you to imagine a woman. Let's call her Amara. Amara came to the United States in 2009 on a student visa. She completed her degree, transitioned to employment-based status, and eventually married a U.S. citizen. She filed for her green card through a marriage-based I-130 petition. During the process, she answered all questions truthfully. Her marriage was real. her documentation was legitimate. In 2019, she applied for naturalization, Form N-400. She passed her civics test, her English test, her background check. In 2020, she was sworn in as a United States citizen. She cried at the ceremony. She called her mother abroad that night. Today, in 2026, Amara is watching the news. She hears about Operation Twin Shield. She hears about denaturalization quotas. She asks herself, am I at risk? Was my case ever flagged? Was my petitioner ever investigated? What if there was something in my file I didn't know about? This anxiety is real, it is widespread, and it deserves a direct, honest answer. For Amara, and for the millions of people like her who went through the process honestly, the legal framework is on her side. Courts have repeatedly held that citizenship should not be taken away lightly. The Supreme Court has emphasized that the government bears a heavy burden in denaturalization proceedings and that doubt should be resolved in favor of the citizen. Former USCIS officials have noted that even with elevated referrals, many cases that reach the DOJ may not result in actual denaturalization proceedings because the evidentiary standard remains demanding. But here is what I want Amara and you to do right now. Not panic, not assume, verify, and prepare. This is what I recommend to anyone who is naturalized, currently in the naturalization process, or has a family member going through the system right now. Step 1. Review your immigration file completely. Pull together every document connected to your naturalization, your N-400, your interview notice, your oath ceremony record, your certificate of naturalization. If you believe your file may contain any discrepancies, even minor ones, document them and understand them before anyone else does. You are entitled to request a copy of your USCIS file through a Freedom of Information Act request, also called a FOIA request. Do it. Know what's in your record. Step 2. Do not make any new false statements. This sounds obvious, but it bears repeating in the current environment. Whether you are renewing a passport, updating your address with USCIS, or responding to any government inquiry, accuracy and honesty are not optional. Any new misrepresentation in any federal document can be used to support a denaturalization proceeding. Step 3. Consult a licensed immigration attorney. Now, not later. If you have any reason to believe your case could be scrutinized, a complex immigration history, a prior denial, a marriage that ended under complicated circumstances, prior status violations, anything, get a professional legal review of your file. This is not fear-mongering. This is basic risk management in an environment that has changed. Step 4. Avoid notarios and unauthorized practitioners. The current climate is creating fertile ground for immigration fraud on the other side. People preying on anxious immigrants who are desperate for reassurance. Only work with licensed attorneys or USCIS accredited representatives. Do not pay anyone to protect your citizenship who is not a licensed legal professional. Step 5. Stay informed from official sources. Bookmark USCIS.gov. Bookmark DHS.gov. Follow reputable immigration law firms and analysts. The information environment around immigration is noisy right now, and distinguishing official policy from rumor is essential. There is one detail most people are missing about where this goes from here. Operation Twin Shield, despite its origin in Minneapolis, has set a template. It demonstrated that USCIS could deploy a concentrated, coordinated, multi-agency enforcement surge in a specific geographic area and produce results quickly. DHS leadership has explicitly described Twin Shield as the first of its kind, with the clear implication that it will not be the last. We are already seeing the follow-on. Operation Paris, launched in early 2026, is now targeting thousands of refugee cases in Minnesota, reviewing the immigration status of refugees who have not yet adjusted to lawful permanent resident status. A federal court has been involved. Preliminary injunctions have been sought. The litigation landscape around all of this is active and moving fast. On the denaturalization side, federal courts remain the critical check on this process. Several former USCIS officials and legal scholars have noted that the government's ability to actually execute 100 to 200 denaturalization proceedings per month is, practically speaking, extremely limited. Each case requires federal court involvement. The government bears the burden of proof. These cases take years. The DOJ's Office of Immigration Litigation has finite staff. However, and I want to be direct about this, the impact of the quota policy does not require 100 to 200 cases to actually complete denaturalization proceedings each month. The impact is being felt right now in the anxiety it creates, in the additional scrutiny it places on pending naturalization applications, and in the message it sends to USCIS adjudicators reviewing new N-400 applications, about how carefully they must examine every single file. The environment has changed, the scrutiny has increased, and that affects everyone in the process, not just people with something to hide. Before I close today, I want to say something that I say on this channel because I believe it, not because it's content strategy. Your immigration status is not a bureaucratic technicality. It is the foundation of your life in this country. It is the reason your children were born here or came here with you. It is the reason you go to work every day, pay your taxes, build your business, put down roots. It is the thread that connects every plan you've made for your future in the United States. When that foundation is threatened, whether by a fraudulent petition you didn't know about, by a discrepancy in your file you're not aware of, or by a policy shift that suddenly changes the standard of review, the consequences touch everything: your family unity, your employment authorization, your ability to travel, your financial stability, your path to permanence. That is why I do this, not to alarm you, not to generate clicks on fear, but because you deserve accurate information, because the people who need this most are often the ones with the least access to expensive legal counsel, and because staying informed, right now, in this environment, is genuinely, practically, a form of protection. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional, it's essential. If this video helped you understand what is happening with Operation Twin Shield and the current naturalization environment, I want to ask you to do 3 things. First, leave a comment below. Tell me your visa category. Tell me where you are in your immigration journey. That information helps me create content that is specifically relevant to you. Second, share this video with someone who needs it. Someone in your family, your community, your WhatsApp group who is currently going through the immigration process. This information could genuinely change how they prepare. And third, if you value factual, policy-based immigration coverage, hit the like button. It tells YouTube's algorithm that this kind of serious, accurate content matters, and it helps more people find it. I will see you in the next video.